Recording started. And welcome everybody to our Monday Zoom and Learn. My name is Tommy Dutcher. I'm the area sales manager with California Title. And my co-host, Mary Jane Morris, is going to be running today's meeting, going over all the potential upcoming changes that we potentially can see from NAR and CAR coming down in regards to some lawsuits. So if the lawsuits do pass, it's going to go into effect. And if it doesn't, we'll probably still see some changes. So this is definitely one of those that you want to take notes on. We will post in the chat the deck that Mary Jane is covering. And again, you can find this recording located on the YouTube channel posted in the chat. So without further ado, Mary Jane Morris.
Hey, everybody, welcome. Thanks for being with us. It's a very important class today. And in your role as agent, broker, transaction coordinator, all of those things, you're going to have an opportunity to really spread the word about this. And it's a very important subject. First, I want to give a shout out to Samantha Mays. I ran your name together there. Instead of Manhays, I just said Mays.
Manhays. Yeah, that's why it's up.
And I'd like to thank her for her presentation on the same subject recently. As we were delving into it, we wound up in a conversation about the National Association of Realtor lawsuits and against the Department of Justice and others. And so we felt it's such an important subject that we should circle back and hit it again. Any thoughts before we get started, Sam?
No, just when we get, because they released it from CAR since we did the last training, clarifying between nominee and assignee, which will be addressed in the revision of the RPA. That's why I wanted to share that, so everybody had that information. And again, it'll still stick with, we need the AOAA, but there is a business practice that when you get to that part, I'll point out that even CAR has said for years, but specifically are addressing now to stop repeating.
Great. Okay, well, before we get into it, we have to have a little discussion, a little important conversation first. So in 2019, what you will remember is the year before COVID, there were quite a few lawsuits that got filed against by sellers and buyers against the National Association of Realtors. Simultaneously, the big tobacco attorneys that conquered big tobacco took on a class action suit for sellers and buyers who think they didn't have a fair chance negotiating. We're going to talk about that a little bit. And then finally, the Department of Justice started an investigation, and that's where we're going to start our conversation right now. So as an industry, in 2019, we were accused of some very serious things. We were accused of fair housing violations. There was a 5-year study that you can find on Google with video that shows people conducting their business with bias. And I don't love the word racism because it's so loaded right now. So I'm going to use the word bias as we go through this. Everybody has a bias. They don't, some people don't like broccoli, some people do. So it's just that easy. So there were some gross mishandling in the fair housing division. For instance, the same home with white people's pictures on the wall was appraised higher than people with brown skin on the wall, pictures of brown skin on the wall. So that, and there are dozens and dozens of examples of realtors, sort of similar to what happened with the city council in LA not too long ago, where off the record they were caught just spewing things that the Department of Justice and the National Association of Realtors cannot allow to continue in our industry. So we got hit with that. We were also charged with being a monopoly, which means that we have a lock on it and we're not going to let anybody else in it, and we're going to name our prices and have a total control through the MLS, through lock boxes, have total control. We were accused of steering. A certain big brokerage that we're all familiar with that does a lot of new agent training. Their leader was called to the stand, and you can also find all these depositions online, and was asked why they are teaching agents only to search for properties that are 2% or above. and eliminating properties that have a lower commission, whatever the reason is for that lower commission. We were also charged with price fixing. These are pretty much the biggest things you can be charged with as a business. So price fixing, because the listing agent negotiates with the seller to set what the buyer's commission is going to be without further discussion between the buyer, the seller and the buyer, all of the other people. So this created a non-transparent situation that basically led to the charge of price fixing. Now, again, I avoid politics and religion in my business completely all the way since I was a child, but I will say that we did have a settlement with the previous administration. The Department of Justice did have a settlement. They were not as hot for policing us as the current administration. The current administration would not accept a settlement that was made by the previous administration without looking at it. And so they have continued to delve into what they needed to know. Tommy, you're taking care of the admins to the admittance. Thank you, sir. So we have all of these lawsuits going on. Recently, the CRMLS put out a little video that outlines for us how we got here. And the reason that we're discussing this before the card forms class is because this is our last update, as Sam said, before summer next year. And if this happens in the early spring or early summer next year, the cases are found against us, then they will, these forms will need to be already ready to go. So that's what they've done. Now, Tommy, I'm going to ask you to run that video, but before we do, we decided to tell you that for those of you who are dialing in from a phone and that sort of stuff, you may experience some breaks. We have tested this in both directions more than once now. I can hear it fine. He can hear it fine. If it's really disruptive, put it in the chat, or you may have to just mute your sound. The video is only 8 minutes long, but it does explain how we got where we're going. And then we can get into the forms and see what we're going to do about it as we get there. But the most important thing that you need to know, the biggest change before we run this video, is the cooperating broker compensation, if we lose this case, will be coming out of the MLS. Their buyers will be required to do a buyer broker agreement on every single transaction and on every single buyer. So the other thing I want to tell you before we get into the video or the class is the cooperating broker compensation on the MLS is that little percentage that you can see that's, you know, what the buyer's agent is going to get paid. You can't see the listing commission, but you can see the buyer's commission. So I want to tell you that every time I've taught this class, we get about halfway into it and somebody will say, oh, but I'm still going to get paid what's on the MLS, right? Because they're not understanding what the reach of this class that we have to tell you about is. If this case is lost, there will be no commissions on the MLS at all. They will be negotiated by additions to the RPA between the seller and buyer. Between the buyer and the seller in contract, and as usual in the listing agreements between the seller. But the seller will no longer be paying, automatically paying through the listing agreement, the commission anymore. This is a big change for our industry. So let's take a look and see how we got there. And I apologize again for the sound.
Tell you, I've been out speaking a lot lately, and as such, I'm still kind of surprised at how many people are not necessarily paying attention to the big picture of what's going on at the national level, what's going on government-wise when it comes to real estate and organized real estate. You guys hopefully have been on my meetings before. You know that NAR has been sued 13 different times. Obviously, some of those lawsuits have been combined. We are talking, buyer side lawsuits. We are talking seller side lawsuits. And clear cooperation policy lawsuits. There's just a wide variety of things, and NAR, rightfully so, is kind of reeling from some of this added attention, plus the fact that the Department of Justice and NAR are involved in active litigation right now as well. So all of that being said, we are at the CRMLS level doing as much as we possibly can to plan for contingencies. And one of the things that's going to be a real bellwether for the industry is the Sitzer and Winger case versus NAR. And this is a seller side lawsuit, and they are alleging that because sellers are forced to pay buyers agents in the transaction, that they have been disadvantaged by, in some cases, the class action lawsuit being held in Chicago, the Morrell case, is a $5 to $7 billion lawsuit. Sitzer and Winger is a Missouri-only lawsuit, and with the trebled damages, potentially it could be a $700 million $700 million liability if NAR were to lose this lawsuit. I quote my attorney all the time, and he tells me, just not in these cases, but just across the board, that even having the law and all the facts on your side, you still stand a 25% chance of losing a lawsuit. And in looking through what we know about this case specifically, the judge has not been highly supportive of NAR's position in a number of different ways, and some of his rulings that have come out. So Sitzer and Winger goes to trial in February of next year. And basically, the judge has already set the parameters that it's going to be a 6-week trial, and everybody needs to get their information in, and he is going to most likely provide a decision back in the March, April, early May timeframe. So Sitzer and Winger will tell us a lot about what's going on in regards to the industry. You guys do need to get your arms wrapped around a different number of things that are going on. Part of the Sitzer-Winger trial, Sitzer-Winger versus NAR et al., and also they've sued the franchisors on this one as well, is that they've asked for a injunction against the National Association of Realtors, if they win, that NAR cannot have the mandatory compensation rule within the multiple listing service across the United States. And because CRMLS is affiliated with local associations, those local associations are required to adhere to the NAR model rule set, and we have done so. And if that occurs, cooperation or compensation could be going out of the multiple listing service across the board. Does NAR have the right and, I believe, obligation to appeal this ruling if it does go against them? Absolutely. And we don't really know how all of this is going to play out, but one of the things I think is important for you guys to get your arms wrapped around and probably take a look at is a couple of things that are going on within your forms products as well. Recognize part of the Department of Justice's lawsuit against NAR is that they wanted 4 things to occur. And CRMLS and NAR have adopted 3 of those 4 things. And a lot of it has to do with transparency to the buyer of selling office compensation, of the brokerages that are involved in the marketplace. And we've accommodated those changes within our platform. So we're excited to get some of these changes out, but recognize that this could be a significant change. CAR has done a great job with an additional set of form products. I think 3 that you at the brokerage community really need to get your arms around and take a look at are, and I'm not going to do them in any specific order, but there is the SPBB that'll be released in December of this year. And it's not ready for prime time yet, but it is a very simple form that basically instructs the buyer's agent to basically include this form as part of their offer process, and by which they are requesting a certain amount of commission be paid to the buyer's broker. The commission will not be in the MLS. The commission will actually be a contractual form that is exchanged in between the buyer's agent and the seller's agent, and the seller will approve. That is called the SPBB, and it's basically the seller's proposal to the buyer's broker. And basically, it is a very simplest form and something that you guys need to get your arms wrapped around. I'm not saying that you need to start utilizing it in December, but you need to wrap your arms around it. The reason why CAR's included it in the latest release is that if Sitzer does go the wrong way in February, their next forms release is in June of next year. They needed to get this form out just in case. So the other piece that you do need to take a look at is that there is a new buyer broker representation agreement, a number of different ones. And you need to be aware of what those are, especially if compensation is out of the multiple listing service. We've been advocating this for a long time at the CRMLS level, that it is in the brokers and agents' best interest to do as much as they possibly can to enter into an agreement with their buyers prior to a offer being presented on a property. It just makes smart business sense, and it stops a lot of the complaints that we hear of wandering buyers and some of the procuring cause issues that we hear. So highly recommend that you guys take a look at the new buyer broker representation agreements. And the last one is the anticipated broker comp disclosure. So you guys know, one of the changes that one of the changes we made last year at the end of 2021 was a change to our rule set, which allows our brokerage community to display selling office compensation on their website. So buyers know what selling office compensation is being offered through the MLS to their buyer's agent. And that, I think, is important. This new form, this anticipated broker compensation disclosure, basically, as you show properties, as you make offers on properties, this form is to be filled out to make sure that you're doing everything you possibly can to assure that the buyer has been made aware of the compensation that you're being offered through the multiple listing service at this time, and in the future, potentially through a SPBB. Okay, a lot of information there. I know, is this a slam dunk that NAR is going to lose this lawsuit? No, it is not, or any of the others. NAR's got 50 years of antitrust case law in their favor. MLSs have, that amount of positive court decisions, but it just seems to the attorneys that I'm talking to a little bit different this time. And recognize that the Department of Justice and the FTC are actively looking into real estate and actively looking into what they call illegal tying situations. And there are some in the current administration that view one of those illegal tying activities is that a seller's agent pays the buyer's agent through the multiple listing service. So just know that there's a lot of pressure out there, and I'm not saying that all of this stuff is going to occur, but I'm just telling you guys, you need to stay on top of it. You need to be aware of what's going on out in the industry, and that there are some very significant changes potentially heading everyone's way. And we may not get all that much time to really get ourselves comfortable with what those changes are. The MLS in Seattle, the Northwest MLS, has already adopted a rule change whereby the seller does offer directly to the buyer's broker a compensation amount. And the reason why that's done is to make sure that it still can be included in financing. Obviously, there's some major concerns that any of that commission that was offered outside of a buyer's ability to finance is going to have some huge difficulties in moving forward for anybody. So we are looking very closely at what's going on in the Northwest, as I know a lot of people across the country, including the government, are as well.
Thanks, Tommy. So, thoughts, questions? Anybody? So, the National Association of Realtors is our trade group. And when I, just a few weeks ago, tried to post on my own Facebook page a discussion about this, I got some very simple replies that forced me to take it down off my page. Many people don't even know that the National Association of Realtors that we give that little $150 chunk of our yearly dues to actually does this for us. From my entire career, NAR has never lost a big case. This is the closest that we've come to NAR having this taken out of their hands. And this is not something realtors want or asked for, or this is a conclusion of a investigation. And there were 4 pieces of it. The fair housing that I mentioned already has a new module that'll be showing up on your continuing education for those who are licensed. It is very interactive. It is multiple choice, but when you choose, they tell you how you practice bias or how you practice steering. When I took it, I can't remember if it was 10 or 15 or 20 questions, but 3 times I called out that I was making a poor decision and that there was a fair housing issue. And so you wind up going back through that test over and over again. I was still honestly a little perplexed, even after the conclusion of that, but you do have a new module coming to your continuing education. One of the big goals, besides the monopoly and the steering and all that, was to get the cost of home buying down across the board, reduction of costs. So this is a direct attempt to reduce the amount of income that the average agent is going to see per transaction. Even though they had said even though we do supposedly negotiate among ourselves with the listing agent and all that, they did a nationwide study, and we're all falling in the 3 to 6% range, just like we've all been taught to do. And therefore, there isn't enough negotiating going on in that 3 to 6%, and they tend to they're determined to mix it up a little bit. So, having said that, I'm going to start sharing forms here. I want to remind you that some of these forms, like the RPA, and we are going to do the regular RPA, I took Sam's good advice and I left property management out altogether. And I addressed the things that I thought were most important to you. I'm not sure I put the assignment in, and Sam made a great point, so she's going to jump in and take care of that if I don't. There is a discussion of assignment at some point in here, Sam, you can just jump in. Questions are always welcome. Feel free to put them in the chat or shout them out if it's very important to you. So I'm going to share screen here. We're going to go to our docs now. All righty, here we go. So it's your residential purchase contract. This last year when we taught the new contract, it took us 2 hours to go, a long time to go page by page. This contract review will go much quicker. So the first thing is the previous edition had defaulted the no points being paid, and apparently that was a problem for some lenders. So they put it back. They put it back to what it used to read. Like there is a spot to put in points if you want to do it. I also point out to everybody that after December, is it 19th or 20th, Sam?
19th.
19th. This will be the date that you will want to be using on all your current contracts.
Oh, something real quick with that. There is a new law going into effect, but it does not start till January 1st. That if moving forward next year, say the new forms came out, but you're already under contract, you don't have to go back and do the updated forms since it's whatever's based off that contract. We are not there yet. So double check with your broker and your E&O, especially with some of the new disclosures that may be required if you go under contract after the 19th, but already have done your disclosures. Just a little reminder, because it doesn't go into effect till Jan 1. And if somebody wants to get particular, that could be an issue.
And then just as a general rule, we can close on any version of the contract. We just have to follow the rules that are in that contract. And then none of them will match up to your other forms if you're using an old an old version of the contract, so,
Well, an E&O typically won't cover you if you're not using the most current version, and CAR forms won't cover you unless you're using the most current version as well.
so at the top of page 2 in G3 here, this is where the form, this is where you're gonna check the box where the buyer's agent is going to ask the seller to pay a share of his commission or all of his commission. That is where it's going to go when we have to start using it. Then in L4, 5, 6, and 7, CAR asks us to remind you that delivery of documents, they're tired of getting this question at the CAR legal office. If you delivered everything except the HOAs and the HOA docs go out 2 days late, the seller buyer still gets 5 days always. So whichever is later, 5 days. They can either the contingency can come out on time. If everything's on time, it can come out on time. Otherwise, everybody gets 5 full days with their documents before they have to remove that contingency going forward. On M3, they added a new rule that if a seller to do a TOPA form every time there's tenants in the property, it's not optional. It shouldn't be anyway, because it's, it has the estoppels and the leases and all the agreements. If you're going to accept a tenant, it has everything in there that you'll want to talk about. So they've added that as a seller document. We're going to go all the way down to Q, where they've made it plain that the home warranty is to be chosen by the buyer. You can ask for a certain company and they can counter and that sort of stuff, but the buyer is supposed to be able to choose top to bottom what he wants for his home warranty. Paragraph 4. Up here, you remember last year for the new RPA, we lost a probate. We lost all of these type of contracts. The probate went out, and the manufactured home purchase agreement. All of those became an addendum that you add to a regular RPA. And this year, there's a new one, a mixed use purchase addendum. I did not add it to this particular class because it's kind of a specialty property, but there is a new addendum for that. 5A, they've tightened the language again. Last year, you might remember that I told you that CAR asked us to stop telling people when they can or cannot get their deposit back. Yes, Sam and I are pretty smart, and we can figure out if we will likely get our deposit back or if we have completely failed in some way. And that there's, but when you tell us, when an agent when anybody tells another person that they positively can or cannot get their deposit back, you are practicing law, and that is outside of your license. Also, there is no such thing as a non-refundable deposit. No matter what, even if it went through the escrow and got handed to them, it might be a little harder to get back, but it is all deposits are subject to liquidated damages rules. And there is no such thing as a non-refundable deposit. Number 7, if a buyer, this is a new rule that if a buyer intends to occupy a multiple use property, like a duplex, and he's going to live in one and the buyer's going to live and their tenant's going to stay in the other one, you must disclose which unit you're going to live in, and it must be vacant at close of escrow. Down here, number D, I just reminded you again that it was the review and approval of documents, not just the delivery of the documents that matters. And we all know how to approve documents, right? We removed that contingency. Again, review and approve for HOA documents in F here. This is the remove in I. This is the last year when we got the new contract, we had some common language where I called that first couple of pages a grid, and this back page is kind of the rules. This matches the grid change up front that they have 5 days or whichever's latest. So for those TCs who are listening, you're going to have to be very careful about when things went out and add the appropriate number of days if necessary, because it's whichever is latest. Last year, we got the tightened included and excluded agreement in our contract, which is, if you guys remember, I taught you that if it was in the property at the time of acceptance, it must still be there at close. No, that does not mean their personal belongings. That means the Nest, thermostat and the Ring doorbells and the security system. If you did not negotiate for it to go, it must remain. And last year they put this firmly in the department of the listing agent. Listing agents need to have a more serious conversation, literally make them stop and walk the rooms if necessary, but they're going to have to be very careful. So last year they added all the curtains and everything, and apparently that wasn't enough because we had to add the new words hardware and rods as well. So we added that as well. And pool heaters. Who knows? I guess somebody took a pool heater at some point. So pool heaters have been added. Number 5 down here, if you guys have, if the seller has services like ADT or an additional service going with the Nest or the Ring, they must at close of escrow remove themselves from that system. Probably the most and cooperate with the buyer getting on the system successfully. I recommend that you add this to your utilities, that they speak to whoever is managing those utilities. The most common call we get is somebody's alarm is going off and they can't turn it off because they don't have the password, because it was the seller's old password. And then we hunt the seller down and he says, I'm not helping. Okay, that is not how that is going to go. You need to take yourself off those services, and when asked, please cooperate with them getting back on the systems appropriately. Okay. Paragraph 10, they added the word tests in here, and they remind us always that inspections and reports and certificates, even a septic where they say they're going to certify it, if once they start the inspection, it turns out that something significant is going there, the seller has the right to go back to the table and discuss with who's going to pay for that. It is not necessarily a seller problem because you discovered it through a test or an inspection. That just like the SWPI says now, it does allocate who's going to pay for this and that, but there's an additional paragraph in there that says, but if it should need more work, we're all coming back to the table to talk about it, and that applies to all inspections and tests. Now, this is the legal that matches up the grid change, that the buyer shall choose the home warranty plan and any additional cost and pay for anything above what the seller won't. Same as last year. I got a whole page here that we didn't have to do anything on. We're going to get on to paragraph 11M. You have a new statutory, a solar system disclosure, which they made for some reason look a lot like a TDS. It has the same rules, meaning you can still say, am I aware? Is the seller aware? However, when I read the document, I don't say if you want to comment on this. It's asking questions like who built it and what type of panels are up there and what kilowatts it is and all that. And most people don't even know what they have on their roof. The shortest path to this is to get a copy of the solar. You're going to need it anyway, the solar agreement. So there is a new solar. I just anticipate, Sam, don't you, that sellers are going to repeat their mistakes into writing, like I have a fully paid solar when they really have a fully current lease.
So the first 2 pages of the form go into the usual, just like the AVID, kind of the disclosures and everything else. The page they're going to fill out is actually some more similar to the SPQ with the different questions and things. What it does, though, spell out, which has been an issue before, is the seller needs to, even if they do have a paid off system, provide the contract, provide connection, provide all those docs. If they do have service, go ahead. It does also talk about electric bills, because a lot of times people are requesting the previous 12 months of electric bills. Now, the issue we're going to have is TC. This is kind of like what happened when the RLA switched and the NHDs to be ordered at the time of the listing. we're gonna have the same issue now where we've got to know, how do we know to put that disclosure in our packet? So the agents are going to need to pay attention and make that a trigger question that they are checking in, is there solar? Because now there is a disclosure, because I don't go to the property, and as much as we can check on the MLS and everything else, we want to make it a practice of reminding the agents, this needs to be in the questions, and we need to get them to start pulling those docs. The sellers also need to contact their solar people to flag them and say, hey, I'm going to sell the property. What do you need to transfer? So that's what this form is going to do, is do a lot of triggering. But I think the biggest thing for all of us to remember is double check your RLA, make sure the agents are having that conversation when they're taking the listing, and get as much info as possible up front, because as we all know, it can be a drag in your feet trying to get all this transfer done.
A solar contract is a written contract anyway, and you're asked in the TDS if you have any written reports or warranties and whatnot you should be giving up. Really, the fastest way to know what you got up there is to get a copy of the contract, and the ones that don't have it need to go get it. Okay, they're not going to be able to. It is going to be tricky for those who are on here that are TCs but are not licensed agents. You don't have the privilege of checking the MLS. You know, back in the day, I would look to make sure if we had a pool that I was covering the home warranty, you know, I would talk to them about covering the home warranty because I couldn't look. But solars have become, I mean, I used to think HOAs were the worst thing ever happened to me, but it's solar now. Although we need it very badly. So in 12.2, they're reminding you that investigation of the property includes fire insurance and flood insurance, the numbers that go with those, because they're very significant. I taught last week for a company that had their insurance agent in the room, and he said that California actually has an injunction right now that they cannot raise their prices because they've lost, I forget, it's definitely would be $2 billion or something in fire and flood and all that. And they said the minute that injunction gets lifted, you can expect a bump in your homeowner's insurance, probably a pretty significant one. So, and some places are having trouble even getting fire insurance. So make sure you're including in your investigations. It is flood and fire, but really mostly the hazard insurance is what you're looking at there. Okay. 14A did have some revision, but it was just to bring all the paragraphs back in line that went along with the grid. So there's nothing new there that we haven't talked to you about. 18 is where we're bringing in either the seller or the buyer or both as applicable according to a separate agreement may be paying the commission. This language is pretty open right now in our form. We already have a form that we're going to show you if this law passes and if we lose this lawsuit and we're all forced into this form. Sam, you want to take number 23 for me on the assignment, since that's right where we're going to be for you anyway.
Sure. Okay, so the thing that came up was, and I don't think we've seen it as much, I typically see clients that will write in Joe Smith purchasing and/or assignee. Well, and/or assignee got removed when the contract got redone in 2014 with the address of assignment in the contract. So you don't need to write and/or assignee. That used to be kind of an open-ended situation. Now, the difference between assignee is assuming the contract. They actually are assigned the contract and taking it over. Nominee comes up when you have somebody saying, well, we're going to create an LLC, or we're going to create this entity, or whatever. And nominees typically do not have the same legal responsibility the way an assignee does. The assignee has assumed. Nominee is just being brought up that they might take it over. If you see either one with the verbiage on the first line saying such blah, 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 and/or assignee or nominee, typically you'll see it a lot for people that do commercial and then come do real estate because they're used to the air forms. You know how it's a totally different contract, totally different situation. Call it out because it could make your contract unenforceable. And so that was that first document, and I'll rethrow it into the chat that just came up from CAR, that was the biggest problem. Some of the verbiage that when they do and/or assignee is a big deal because it can make the entire contract unenforceable. That's why we have the AOAA. If you are going to sign the contract, you got to go through, and that means they sign everything, not just the little bits. You can do The form does allow for the new buyer to only initial the very first page of each document. However, I am a paranoid freak, and so I am worried that a lawyer is going to go through and go, well, they never saw this. Nobody pointed out how many pages this was. So I'm a big fan of, if somebody, wherever the original buyer initialed, next buyer should do as well, verify all with your broker of record. But that's what you need to know is the biggest thing is the adding the verbiage of nomination. Typically it's like, we haven't put the LLC together yet, but a nominee does not have the same responsibilities that an assignee does. A nominee is like, we might get there, but it might not. So make sure you're paying attention to this. And again, documenting your file the same way.
Also, a escrow and the lender have not been brought into assignments fast enough and cause a lot of damage there. So everybody needs to get that information out to the other parties on the team.
And assignment does have a time frame now. It didn't before, because we all got those fun contracts right before close when we're adding everybody on. Currently now, based on your grid, it defaults to 17 days. And then after that, there's no more assignment of the contract, or everybody has to come together and agree, but it's called out.
That one, I have no choice but to tell you that, you know, before we even had assignment language in my career, assignments were happening, and escrow were comfortable with the rules of it that are now in the AOAA, that we knew things about what the duties were of an assignee regardless. CAR reminds you that assigning almost always means a better buyer. It usually means somebody's bringing in the bank of mom and dad, or they need to assign the entire transaction off because they aren't qualified at all. So, and it would be just wrong for me to tell you that assignments aren't going to happen on day 29. They are for sure going to have happen. And it's probably the number one question I answer other than trust. The entire file does need re-signed top to bottom. And I'm with Sam that initials aren't enough for me, especially at the speed that they read the DocuSign moves through things anyway. So it's going to be hard for me to say in court that I'm comfortable with that signature when I can see the entire package took them 90 seconds to sign. So all right, legal holiday. They because of all the different counties having different holidays, some people do Cesar Chavez, some people do Indigenous Peoples Day, some banks are closed for California holidays, some aren't. So if your escrow, your title, or the recorder's office is not open when you're ready to record, there is an additional business day. So that was to clarify what's a legal holiday. If you're not Jewish, is it always Christmas is and Hanukkah isn't? It's this is a good example of, so if a key player is offices are closed for a holiday, you will get one additional business day to close. Excuse me. They did add a sentence that said that electronic signatures are built into part of the contract. Now they're okay. They added a sentence to the arbitration clause, paragraph 31, that says that after arbitration starts, an attorney can keep beating on you through, writing you letters and asking you to change your mind and all that sort of stuff, but they do have to stay any action, and they do have to give you a letter saying they've stayed any action. They can't continue threatening you with a lawsuit until arbitration is completed. You are entitled to a stay. All right, they're still trying to get you guys. I'm on page 15 now. They are trying to still get everyone on board, understanding what authority a person who is not an individual has, whether they're a trustee, a president, a managing member, an authorized signature. This one has always caused people from escrow like myself to have kind of a chuckle, because escrow has to dial into this the second it becomes a transaction anyway, and then you're going to have to show it to us all. Anyway, so, but it is intended to get your head into the game as to what their status is, if they're saying they're a trust or an LLC. But what I really wanted to talk to you about, and Sam and I talked about this when she gave her update class a couple weeks ago, that you can't fill things out for a seller. You can't, you're not going to know whether he's the president. You're not going to know whether he's the managing member. You're not going to know his situation. You're also not gonna know the listing agent's proper email or phone number, any of that sort of stuff. We had all gotten in the habit over the years to fill out as much as we possibly can, trying to be good agents and hope that the listing agent would find that we were thorough and find our offer the best offer. But you cannot, there's a rule that you cannot go back and sign something over other people's signature, above the signature is what they call it. So Sam and I have heard in the last class a couple of techniques. One is sending just this page out and having everybody initial it, which is certainly something. I'm not saying it wouldn't work. But the proper way, and you need to accept it now, take a deep breath, TCs. You will be doing the delivery of documents. Again, yes, you are adding it to you. Just like when we do an AC to clean up the agency, those are just going to be routine in your life now. Yes, embrace it. Just it's better to clean it up with the correct forms and send those out than damage a contract by writing on it above. You could literally put the initials over something that somebody needs to know on top of it. So it's not a good practice. It's better than nothing. What do you think, Sam? Better than nothing? I can't go
Better than, okay, we are not lawyers. I'm not going to give legal advice on adding anything to a contract. What I'm going to say is intent is always, part of what's taken into it. Just plan on the DEDA. If it's not on there when you get the contract, turn it around and do it right away, because the problem is electronic delivery is now the key term. And without having specific, where are those two electronic deliveries? Once you hit email, once you hit send, that's considered delivered. And we can't fight timeframes if I don't have something in a contract to tell me what we've all agreed to. You can't. It basically blows everything out of the water because you have no proof of delivery to go everything else. So that's, if you understand the why behind it, it helps. And if you can explain to your agents the why behind it and how it could impact, I don't know, getting a commission, it might be able to get them to start paying attention to it.
It's not a great practice to write it above people's signature.
Yeah.
The broker section now here, you'll see that they put the email address, phone number, and contact information back in, so that I got calls from the escrow officers on my team that as soon as this offer started getting used, that they have no way of reaching the agent on the other side because there's no information on it. It's not on the listing, not going to be on the MLS, even if you had access to it. And then they did also mark a box that you can say where you want to be delivered. So if they oversimplified it last time and they cleaned it up this time. Some people do not want to get, this has come up for me this year, some people do not want to get their notices by text message, and they will leave their number off. They will only put an email address. Also, please remember that if you send so a realtor uses more than one email address, and you've been talking with them on two, but that's not his delivery address. If it was a notice to perform or demand to close escrow, you have now done it wrong, and it will need to be done over. So knowing that you've talked to him at his info at email the whole time, and now you go and look at his delivery and it's really Bill at World Realty, you better be delivering where the person said that they wanted to be delivered. And it's on them if they don't. If they're in Cancun, this is why we changed it in the first place. If they're in Cancun and laying by the beach and not checking their emails, that delivery has been made.
Well, and I'm going to step in real quick. I know there are a lot of great TCs and assistants and everybody else who are willing to be the alternate or put their information on there. Unless you are a licensed agent or you are part of that exact same brokerage, I see it as a huge potential liability. You are now becoming part of this contract. You're becoming part of delivery. Let's be real. The market's changed. People are not making the money they were, and things are a little bit grumpier. So we need to make sure that you stop, think about it. Yes, everybody wants to be a service oriented, but be smart. And if you're not party to that and you're not going to do any of the negotiations, your information should not be on there at all.
When Neil Kalin was teaching this class from CARD, he made the comment that perhaps that would be your TC, and Sam and about another 100 people fell on him immediately after the class to let him know that we don't have agency and we don't receive delivery of documents.
Neil's my best friend.
Unless you have agency, you do not, you don't want to be on there. Okay, now, despite what the CRMLS gentleman said, and I think the reason he said it was because if you look at the little graph, you will see that it appears that we got 5 new buyer broker agreements. We actually eliminated them all except this one. The buyer broker agreements that you will find in your computer right now are exclusive, non-exclusive, on and on and on. This one is built, has everything built into it. It can be exclusive, it can be non-exclusive. It can be for one property, it can be for a whole bunch of properties. It can be for a zip code, it can be for, in fact, when I used to teach buyer broker agreements, I told people to phrase it as a shopping list. Let's get your dreams on here so that we can shop for them. The difference in this one is it's not going to have a start and stop date. It does have a start date and it has to end in a certain number of days. I think maybe, this is just my professional guess, but I think they were trying to make it different than the listing agreement to a degree and still have a start and stop date. So it could be for one day, it could be for 3 days, for the whole weekend to show properties, it could be, but if you want to get paid, you're gonna need a buyer broker agreement after this lawsuit settles and DOJ is finished with us. So I've heard a lot of good comments back and forth. Some people said that this was very similar to having to get people's addresses for PEDS during COVID, and that there was some benefit to that because it was harder to ghost you or for them to go away. And so some people are liking this. It can also, as you see, it can be for a percentage, a flat fee, for, or some other agreement attached elsewhere. There was another form for that. It does default to non-exclusive, meaning the buyer can sign as many of these with as many realtors as he wants, unless you mark box number 2 and make it exclusive. The cancellation of this buyer broker agreement has one big difference. It's unilateral. Either party can cancel, can ask to cancel, and after giving notice, cancel. This one got a kind of a roar from the crowd when I taught it this week, that particular thing, that a person could let you show them the property and then 2 days later go deal with the listing agent because your buyer broker had expired. And there wasn't much I could say that would protect you from that. But I did hear, I felt like CAR was trying to let you out, let the agent out of the transaction when a seller is unreasonable or cannot qualify. You can give notice and back out of representing them. You didn't get along, whatever the situation is. I've been telling people this in a way, if you want to think about it, that for buyers agents going forward, this is going to be like every property is a FSBO, and you're going to need to find out if they're cooperating and how much are they cooperating and like that. We do think there'll be a little rush to the listing agents, but I told them don't get too excited either, because this whole investigation, one of the 4 points of it was to reduce commissions across the board as a housing expense. And so it's just a matter of time before those commissions start coming down as well, or the seller feels more empowered, especially with the language that NAR is going to have to put out after they lose this case. There will be public releases of information. And so people are going to want to negotiate, and it's the intention of it. There is a box in here that lets you make it non-cancelable. For some reason, you can get that. You will indeed need to give an accounting of your how much money you made. One of the big agreements was that buyers will be more transparent. Young buyers agents or new buyers agents have a tendency to say, I'm free to you to buyers. They will indicate that there's no cost to the buyer when that is not true. They've always been paid. They are not free. It is part of the cost. And this was the only way we could stop people from saying that. All right, number E here, just like in a listing agreement, if you want to retain your rights on certain properties for a certain number of days, you have to fill this in, whether it's 3 days, 5 days, 10 days, 30 days, whatever you think's fair in your arrangement, or so very similar to the listing agreement. And also similar to the listing agreement, if you want to be paid on those, you have to give the person a list when they cancel or when this expires. Years ago, as a managing broker, I made up a little rhyme for it. I say you have to name it to claim it. So just the same in listings. Lots of listing agents put 180 days in there, but then when the listing cancels or expires, they don't give a list. Without the list, there is no agreement that you are going to, no matter how many days you write in there, you could write the rest of eternity in there. If you didn't give them the list, you're not. So we've been having little conversations with agents about how they're gonna keep track of every property they showed when they've showed 50 properties. The young techie crowds said they'll use their iPad and have them sign the MLS. You know, I would tend to drop all my MLSs in a folder so I could keep track of how many I showed them. It's going to be up to you, but if you want to get paid after your expiration, you will need to deliver the list with it. Okay? And then F is this disclosure of anticipated payments. These are new forms that we're going to show you as we go along here. Just takes just a few more minutes and we'll be there. You can still get paid through escrow as long as they do a CDA. You will still need to do agency. And I imagine once this is settled, these matters are settled, I imagine like everything else, it'll be bundled in the zip forms with the agency and the fair housing and the wire and fraud and all that sort of stuff. Another one in 7B that the agents are really liking is that the buyer is promising within 5 days to get pre-qualified and provide proof of funds. And you could back that down to 1 day if necessary. But this doesn't insist that they get pre-qualified and get their pre-approvals ready. In number F, if your buyer turns out to be a big fat fibber and he can't qualify and he doesn't have a job and he doesn't have any money and mom's not going to co-sign and all that sort of stuff, and it causes losses to the seller, agents are not, they're indemnified from the loss of that, providing they didn't participate in it. If they were as bamboozled as everybody else was through the transaction, obviously if you did something fraudulent, like prepare something for them or something like that, or negligent, then you would still be able to be brought into it. But generally speaking, if a buyer is not who he appears to be, you are not responsible for their actions. Mediation will remain, but not arbitration. It does say that these are the forms that are going to be attached once they, so that is the new buyer broker agreement. This is one of the forms that the CRMLS attorney mentioned was not quite ready for prime time. This is the anticipated broker compensation disclosure where you're going to say which properties, when you're being shown or when an offer is being made, who's paying you how much and where it came from. Right now, the MLS is still in there, and so is the cooperating broker compensation. This form would be revised next June to eliminate both of those if they take them away from us. I also had a good question, Sam, and I'm going to send it off to Carr as well. That what about when I give $1,000 to close a deal, or I have to pay for the home warranty or something? I personally am not uncomfortable, as long as it's not signed, overwriting zip forms and putting in there that negative $1,000 for the home warranty or the money I had to kick in, so that you're giving a full disclosure of what you earned and what you had to give back for whatever reason. So there will be a final compensation from people other than the buyer.
I agree with you. I think this is going to be similar to, as we saw with the cancellation form, where they forgot to put what if there's no deposit included. I think these are going to be, as they always are, working documents and expect evolutions. And I would just be planning mentally that June is going to be a huge forms revision and be ready starting like May through April, or excuse me, April through May, kind of checking Carr, because we're going to see a lot of stuff getting tweaks as this goes into actual in the field usage. And then again, next December is going to be probably a pretty decent one as well. And they have what, as we did during COVID, I would expect that if something comes up, we will get updates at different times than we did. So remember, we got October updates during COVID and a couple of other times when we needed forms.
That COVID form was really exciting because I was in one of those situations when it happened, and that update delivered at about 8:30 that night, and I think I had it on the street by 9:15. So it was a very important update. Buyer's transactional advisory, similar thing like the seller's advisory that goes on a listing. Don't lie and do your jobs and get your financing and get yourself ready. And All right, so you can cancel a buyer representation agreement. This is a cancellation form for that. And you're gonna talk about whether were compensated. And just like when you cancel a listing agreement, it has descending list of available fees, full commission, all the way down to no commission is owed based on the compensation. When it's being unilaterally canceled, you can use one box. When it's mutual, it can be signed down there. This is again where that form, if on your buyer broker agreement, you said 10 days after this, you're gonna have to repeat the 10 days here, and you're gonna have to give the list. This is where the list goes that you need to turn in. Okay. And where would you list these things? Obviously, you could attach them in an Excel file or something like that, but you would attach it to something like to this form. It's another new form, the notice of broker involved properties. This is for, I started on this date, we commenced on this date. The broker involvement means acquire, lease, sell, buy, rent, whatever it is, and then what properties. I kind of like this one, that they're reminding people to notify the new broker that you have, if you're going to move on to a new broker, that you may have an existing arrangement with, as a broker, when I've had to call somebody and tell them that that we were subject to a buyer broker agreement, that agent will often start arguing with me. So on behalf of their client. So it's an important step to make sure the other agent knows that there may be dual compensation owed. This is the seller payment. This is the form that will match the grid on page 2, where when the buyer is asking the seller to pay a portion or all of the commission or a flat fee. This is going to be the new form that you attach. So if you do a buyer broker and it says you want to earn 3% and the seller will only pay 2 or 2.5, you were either going to have to collect from your buyer or prepare to waive that amount. Also, if you told them 3 and you got 2.5, you must credit it toward the 3% that they owe. You're not going to get 3 from them and 3 from them. That would be the opposite of the intention of where we're heading. So this one I always find funny and kind of a breather in this class. So we just went through that whole year where everybody 50 grand, 100 grand over, no contingencies, no inspections, nothing. Carr thought that was probably not a good idea, and so they created a form to tell people that that's not a great idea. It's a day late and a dollar short, but it is now in our library going forward when people make non-contingent offers, that there is potential for failure, that you won't be able to recover your deposit. You may not be able to recover your deposit. I want to fix my own language there. It's the solar advisory. I've been saying pretty much this is all blah, blah, blah things. And then this is the one Sam was talking about where, does the solar system provide power for what's the exact size of the property? So I'm going to see a lot of incomplete solars, I'm guessing, going forward. And that we may have to put down at the bottom, please see full copy of the entire purchase, contract or lease for that solar agreement. I think we're going to have a lot of corrections here. Sam, any comment on this one?
Well, I'd also bear in mind, and right now it's not in the contract, but think as it is with the TDS and the SPQ specifically called out in the RPA, that if those boxes are not checked, you do not have a fully executed document. And that could be an issue of delaying your contingencies. You're better off having them either line out and say, unknown NA buyer to verify all, but they need to respond that they did visit each question, verify all with your broker of record, but it's going to come up and they're going to get kickbacks on either side for not having a complete document, which goes back to why it's so important when they're during the listing period, especially now that the listings are taking a little bit longer. Let's get them involved to get those sellers doing their disclosures and reviewing documents and finding these contracts before they are packing up and everything's in boxes. And sorry, we just can't get it.
A shameless pitch here is consider my escrow for the pre-escrow procedures. Because we collect all of that for you while there's time to do it. We will reach out, we will we will encourage them, we will tell them what comes next. We will walk them through the first half of the transfer, all of that before you're even in escrow. And there's always no charge for that because it's not a real escrow. So as long as it doesn't have an escrow number, all of that work is complimentary to you. And I hope that you take me up on it. So cancellation of contract. What could be wrong with our regular cancellation of contract? Well, again, younger or newer agents tend to lean toward mutual cancellation. I called you up, you said, okay, fine. All right, that is not mutually agreeing. That is, you're telling me that you can't go forward. So in cancellations, you will note there is only a buyer or a seller's signature there. Okay, one party cancels, not both parties. One party cancels. The buyer either cancels because they have time left and a contingency left, or they couldn't complete the negotiations on a request for repair and they don't want the property anymore, material facts, that sort of stuff. But a seller or a buyer is canceling this transaction and not both. And the way that they are making us stop marking mutual is mutual cancellations are now only proposed. If you want to use mutual cancellation, you're going to have to propose it and it will go over. And if they don't reply in 3 days, it's not canceled. Okay, so I think most of us are not going to be using proposed a mutual cancellation going forward. And the intention of that is first, because there is legal obligation to who cancels, and if you did it correctly and has major impact on your damages discussion. And so in fact, there will be times when you speak to me where I'll tell you, do not write the cancellation, wait for that to come over. Okay, you need to sometimes not be the person canceling. Okay, if you don't have a right to do it, you cannot just throw it against the wall and see if it'll stick. If you want to, you can try to propose mutual cancellation, but they get a right to answer. Okay. The sad part for me was this took that nice clean form onto 2 pages. The rest of it is pretty close to exactly what you've seen before. It cancels the escrow, keep the deposit, give the deposit, split the deposit, pay escrow, pay off the HOA, hold some, keep some, whatever's going to happen. So the rest of the cancellation is pretty close to the same. Now, that concludes for me the car forms update, and we'll take questions now, or how do you guys feel about the any questions about the big change coming up?
I had one question
Okay, Jason.
for the seller proposed commission agreement. So that's supposed to be done at time of contract. And so, I mean, what if 2 agents are now, the deal's not getting done because 2 agents are fighting over commission now? I mean, that seems to be going to be the new hot form for agents to be battling on.
Or your guy doesn't need any money and he's saying 0. He's going to get paid by his buyer, or he's or the commission is $5,000 less expensive. These are just like every other unnegotiated matter, they become something that has to be worked out as we take it on. So once we discover the problem, we figure out how to solve it, and eventually there's a resolution. So that is not a real legal term, by the way. I think I made it up years and years ago, because agents would call and say, this happened and that happened, now what? And I'd say, you have an unnegotiated matter. Okay, you've identified what the problems are. Now you need to get together and figure out what the solution is. Does that help?
Yeah, it seems like agents are going to I'm going to write 3% every single time and send it over. And now I'm going to lose, potential deals, or the new 1% listing agents that are out there. There's going to be all these 1% buyers agents out there. And so it just seems like it's going to slow deals down, not make them faster, which is a bummer.
And then just for clarity purposes, this is my oldest son and 3rd generation realtor in our family, Jason. I was trying to figure out how I was logged in twice, but I thought I'd go ahead and mention that. Anybody else? Yes, Jason. Oh, you were saying hi. Any other questions or,
If you scroll back through the chat, I've thrown a bunch of the forms that Mary Jane talked about, just so you can have the draft copies. These are always available on CAR. You can look up new forms drafts, figure about 2 months ahead. So typically I check in October and in April and just start checking. So you can get familiar with them and get comfortable. They cannot be used. They have draft across them. They're subject to, still could change, and all of that fun update stuff. So just make sure you get familiar with them, because there's little nooks and crannies. Our other recording, I went through a little bit more on the other disclosures, not as much also the contract. So you can find that on Tommy's YouTube channel.
I also want to mention for the TCs in the group that this is all of these classes, new forms last year, car forms updates now, and the big one that we will certainly get again in June, are all excellent opportunities to display your knowledge to your clients, either by Zoom or since Sam and I, we've been following all along, but we really didn't hit us in the face until we saw the car forms update. I have already booked, I got a list of classes over here. I've already taught 5 and I've got 8 more booked, and it is a really great opportunity. And by the way, if you don't feel comfortable doing that, I would certainly go, and Sam would go.
Oh, yeah.
Sam could certainly, maybe another TC doesn't want to take Sam, or another escrow doesn't want to take me, and same for Tommy, but we can switch up and make sure it's level and fair for everybody. So
Our priority is getting the information out there. I mean, yes, all of us can always use referrals, but it's much easier if the other side knows what they're doing when we're working on a file. So let's get the word out there. That's the big focus.
like I said, I've had a lot of open mouths and open eyes when I'm done with this class, because nobody was really following along what was, that's why I thought the CRMLS attorney was so clear about that, how he's still surprised how many people are not even aware. A little bit of Googling, you can read up on what we were charged with and what the solutions are being proposed.
I was reached out to by a TC after the last class who took it to their file checker, to all their people. And it was a straight up, no, it's not happening. No, I'm on car forms. No, we're not talking about this. I said, did you screenshot her the new contract that you're getting? And yeah, no, that's not gonna be an issue. We don't have to worry about it. They don't want to talk about this. And we need to know, because buyers agents are going to need to know how to negotiate. This is going to change the entire dynamic of a lot of their presentations, how they interact, and a confidence level to make sure that they can keep doing it. I think we're going to see even more of any agent I've talked to so far. A lot of them are like, I'm done. I already had issue. I'm done. So it's going to be interesting. It's going to be an interesting year.
What you think, Tommy? You're muted, my friend.
I said I was looking in the chat, and there was a last minute question here that did say, are all the forms to be used starting December 19th? That was a question, or some of them later in June.
It'll be as soon as they are released in or zip form. So as soon as you have access, and they may not be released on the 19th. We've had them do delays, but that's when it's currently scheduled that they're supposed to. Again, that's all up to CAR and when they drop stuff. But as soon as they are dropped, and you should be seeing it, should change in any of, if you use the CAR or any of that to get your docs through zip forms, your templates will automatically update. However, any files you previously created will not. So make sure you're double checking all of those docs, but that's when you'll see it. And I know I'll be blowing it up on my Facebook, and I'm pretty sure MJ and everybody else will be too.
And then we'll probably be teaching the other half who weren't. And in fact, I've been making this dual comment toward the end. Congratulations on being the first people to put your bottoms in the seat and get it learned and absorbed and ready to talk about. And on the other side, if it doesn't happen, it may not happen this, you know, like I said, we could win or we could lose, and they appeal it and they stay the judgment until I don't know exactly when it's coming, but this is definitely the intention. So never ever would we bring this to, we're in the exact same boat CAR is. We had to tell you now to get ready in case it happens before the next update.
Better to know it and then not have to deal with it than you can get broadsided. And the same thing, it's an opportunity to get with your clients. It's also an opportunity for agents to really review how they're connecting with their clients, and moving forward, just being aware and sharing knowledge. It's something they can be pointing out and saying, hey, did you know this is potentially coming down. I'd like to keep you informed about the differences in real estate. So they're not just going for, give me your business. Let me be an educator. Let me be a knowledge broker.
I've had to do a little educating on our trade association, NAR, as well. Many people think because they don't provide MLS services that they're just some sort of fee grabbing agency. Honestly, the other one I can mention to you for sure is we would all be employees if it hadn't been for NAR by now. They have been after us for 30 years to turn us into tax paying, withholding employees of a broker. So they've managed to hold that off all this time. And that attorney is right. They do have 50 years of antitrust. They know exactly what they're talking about when it comes to the benefits of a cooperating broker compensation. But it does appear that this may be forced upon us regardless. Try not to be too mad at NAR. They're the ones who are trying to save us.
Well, and it may not be the whole black and white thing. We may be in a be ready for this to be some variance of it, some type of, we can do this, but we can't do that. So it's like during COVID with the peds, just be ready. There's going to be a lot of different forms coming. We've dealt with it before. We'll figure out solutions. We'll make it work.
Next week, we have Tiffany from the credit repair. There has been a major change in credit repair. The very best of them had DOJ licenses that had to be approved once a year. And even those have been removed now because of all the chicanery out there in credit repair. Tiffany has merged with the Department of HUD and will be bringing us the most credit repair solutions legally available next week. Sam will bring us the new laws on the 19th, and then we'll take a break for Christmas. I think we're off, did you say 2 weeks at that point?
I think, yeah, we said we could because of it where it falls this year. Everybody will be off on the 26th and the 2nd. So we'll be back, I believe, on the 9th.
This does conclude the recording portion of our event. Thank you for being with us. We don't sign off